My name is Prudence Beaumont and I am a family barrister at Dean's Court Chambers. I'm going to talk to you today about Practice Direction 12J and the correct approach to applying this practice direction within private law proceedings. I will work on the basis that all of you are familiar with this practice direction. The starting point for this talk is the harm report published in June 2020. Its full title appears on the screen before you. It is a report which has been referenced in a number of recent cases relating to issues of domestic abuse within the private law sphere. I wrote an article for the Family Team newsletter in respect of the harm report in relation to Section 9114 orders. That talk is available on the Dean's Court website and sets out the background to the harm report. If you have not had opportunity to read this report, it is ever increasingly essential reading for family law practitioners, but its recommendations appear at page 171 to 187. In summary, it gives consideration to the presumption of parental involvement and questions whether this further reinforces a pro-contact culture which detracts from the court's focus on the child's individual welfare and safety. It also makes a number of recommendations in terms of a reformed private law system and explores various options in terms of advocacy, representation and support for children. It looks at the enhancement of special measures in accordance with the Domestic Abuse Bill, a bill with which I am sure you are all familiar. And it also considers the use of Practice Direction 12J, the use of Part 3, Practice Direction 3AA, and the use of Section 9114 orders. The two cases before you on the screen are linked to one another. The first is a Court of Appeal case heard before Mr Justice Peter Jackson, or rather Peter Jackson LJ as he now is, and it considered an appeal as to whether evidence should be excluded from proceedings in another jurisdiction relating to the father's new partner, which purportedly evidenced the father's controlling behaviour in a new relationship in similar terms to those alleged by the mother in her relationship with the father. The case refers to the harm report. It particularly considers whether or not the use of Scott schedules are useful where allegations of coercive and controlling behaviour are raised, and identifies that the use of Scott schedules means that they often disguise the subtle and persistent patterns of behaviour which are involved in allegations of that nature. It also looks at the definition of domestic abuse and the approach as outlined in Practice Direction 12J, and in particular the definition of coercive behaviour, perhaps drawing into question whether that definition is appropriate and sufficient. It is characteristic of Jackson LJ in that he distills the question as to whether there should be a dispute, where there is a dispute of the admission of evidence of this kind, into two easy questions. One, is the evidence relevant as potentially making the matter requiring proof more or less probably? If so, it will be admissible. And two, is it in the interests of justice for the evidence to be admitted? And that then calls for a balancing exercise as factors identified in the case of O'Brien and Chief Constable of South Wales 2005. The case is remitted then for rehearing, and it is before Mr Justice Hayden. That is it in the form of F and M. He considers the case in relation to two cases in which the father is essentially the common denominator. By the point it comes before Mr Justice Hayden, the father has conceded that the evidence is admissible for the purpose of the hearing before Hayden J. It's a fascinating judgment. It is a lengthy judgment, but I urge you to read it. In part, it looks at coercive controlling behaviour over a long period of time, because the advantage that Hayden J has in that case is the ability to consider both cases together. And he is quite right when he says that illuminates the type of behaviour exhibited by the father. But in particular, I found, as Hayden identifies, that the chilling repetition of the identical behaviour in relation to two very different women is quite stark. He makes extensive findings in relation to coercive and controlling behaviour, and he quotes extensively from the police interviews that the mother conducted at the time that she was subject to coercive and controlling behaviour. That is in part why the judgment is so lengthy, because there is extensive reference to police disclosure. But Hayden J makes no apology of that, because it does serve, as he rightly identifies, a very useful way of identifying and revealing both the truth and credibility of her evidence, but also her naivety and the failure of her at that early stage to fully grasp the nature of the abuse that she was subject to. In my view, that is a fascinating point, because many practitioners will have had experience of representing victims of domestic abuse who are still so close to the abuse itself that they do not truly recognise the harmful nature of it. They accept that it is bad, but they do not understand, because they have been under the control of an abusive partner, the extent and severity of those behaviours. The judgment unpicks many differing aspects of controlling behaviour. It looks at financial, food, communication, impact on physical restraint, emotional torture, the impact on the family. There are many features which many of you will have had experience of in cases. It is useful reading to see how Hayden J deals with those issues. He also sets out, I think very usefully, a combination or contrast really between the definition of coercive and controlling behaviour within Practice Direction 12J and as the offence under Section 76 of the Serious Crime Act. It may be useful for you to consider the review of that offence. So the Serious Crime Act, as of March of this year, there has been a review of the efficacy of that as a new offence, and I have detailed the references of where to find that report within the handout that accompanies this talk. Finally, he discusses, again, much like Jackson LJ, the value or lack of value of Scott schedules within private law proceedings which feature allegations of coercive and controlling behaviour. Hayden J was invited to give guidance on the use of Scott schedules. He refused to do so, but in refusing to do so noted the following, that they had severe limitations, and he questioned whether or not they were even a useful tool. So you will note that there is now a question being raised. It begins in the harm report. You can see it being tracked through these cases in particular as to whether we are approaching allegations of domestic abuse in the correct way and whether we are using the right tools to approach them within family law proceedings. That brings me on to the Court of Appeal conjoined appeals. These were heard at the end of January of this year. You will note from the title on the screen before you that 2 of those 4 cases relate to decisions made in the first instance by His Honour Judge Tolson QC. That will be a name that you are familiar with because of the appeal last year in respect of allegations of serious sexual assault and rape, and which on appeal he was severely criticised, and it appears that his approach again is under scrutiny from the Court of Appeal. The conjoined appeals were, as is often always the case, open to the public, and you were able to join on a live link to hear the appeals as they took place over 2 days. A number of journalists did, and the most useful analysis I have found of that is on the Transparency Project website, which cites in 3 parts, tracking through that case, and references the Twitter feeds if you want to read back on the live transcript of what was going on. The Transparency Project identifies the following areas as displayed on your screen as being relevant to consider within the Court of Appeal conjoined appeals. Firstly, how these hearings should be taking place, the issue of marital or partnership rape, and the link to family law within criminal law. That picks up on the point raised by Hayden J in the recent judgment to which I've referred. The treatment of coercive and controlling behaviour in the family courts, that harks back again to the harm report, but also has been raised in those cases to which I've referred. The use of Practice Direction 12J and how it is to be applied, together with Practice Direction 3AA, again, recommendations as detailed within the harm report. And then following the finding of fact hearing, what the proper approach should be if either there have been findings of domestic abuse or the allegations have been dismissed. And again, that is referencing the considerations as raised in the harm report in respect of the pro-contact culture approach and whether that is the right approach or not, and again questioning the presumption of parental involvement. The President of the Family Division very recently gave a talk to Royal Holloway. It is again detailed, I think, very well and usefully on the Transparency Project website, and within that he makes reference to the conjoined Court of Appeal cases for which we are still awaiting judgment, and notes that it is likely that the recommendations are going to be quite difficult reading, but that there is clearly a need to review and consider how Practice Direction 12J is being used and whether it is being used properly and correctly within the family courts. So really we await that judgment because it's going to be huge in terms of how it dictates the further progression of dealing with these matters in the family courts. But I would certainly encourage you to go back and read and consider the issues as considered within those cases. And it is clear if we look at the progression from the harm report going forward in recent months that there is a development in this area and a clear warning being raised on the higher courts about the proper approach or moreover the fact that it is often being dealt with improperly. The references referred to within this talk appear within a handout that accompanies this talk, to which you are welcome to read and refer.